Hello and welcome to the Sikich Human Resource Advisory Services presentation on How Long Do I Keep It? A Practical Guide to Record Retention. How many of you have heard the saying, if you don't have a record, it didn't happen? This old saying from human resources and management circles has never been more true than in today's environment. It all boils down to having records and having good and accurate records. We will focus today on record keeping and notice requirements for a number of key federal employment laws. As an HR professional, our team often hears the question, how long should I keep this document? Today we will discuss the following. We'll begin by highlighting the importance of records and notices and comment on retention, storage, and destruction of records. Next, we will review the record keeping requirements of key employment laws so that you will be familiar with the basic rules. Then we will discuss notice requirements so that you will be aware of what notices need to be posted and how long to post them in compliance with the laws. You probably know some of the negative effects that can happen due to a lack of compliance with record keeping or notice requirements, such as being penalized for breaking the law or being unable to defend the organization in a lawsuit. However, there are also positive reasons to make sure you are in compliance. Records and notices are among the best ways to demonstrate that your organization is treating its employees ethically, fairly, and respecting their rights. Accurate and thorough records are some of the best evidence of good organizational citizenship. Notices can have a similar positive message. Well-trained employees are aware of their rights. Notices are not only legal requirements, they are also training tools to be used to keep your employees informed. So let's not lose sight of the positive dimensions of records and notices. Federal record-keeping requirements are extensive and sometimes confusing, as are notice requirements for the various laws. To help sort it all out, today we will cover the basic information you need to know about the record-keeping and notice requirements of major employment laws. I will highlight some of the more important record-keeping requirements that apply to most employers, regardless of industry. Employers should keep in mind that the time period for retaining records set forth in the various statutes are minimums. Since these records are critical to the employer, if compliance with federal or state law is questioned, or if it must be defended itself against employment-related litigation, employers may want to retain employment-related records for much longer periods of time. Complete and accurate records are often an employer's best defense to employment-related litigation and wage and hour complaints. In addition, some states have specific laws related to maintenance of personal files and other documents that may require longer retention periods. Most employment laws require employers to keep records covering employment decisions and actions and to post notices concerning the provisions of these laws. There are several benefits to complying with these requirements by keeping good records. First, record keeping assists in maintaining human resources by providing hard data on the effectiveness of policies and procedures. For example, records of accidents in the workplace help identify why accidents are occurring and how to prevent them. Next, records help to demonstrate compliance and cooperation, not just with record-keeping requirements, but with the broader purposes of government laws and regulations. For example, documentation of equal employment opportunity practices can help show that an employer is in compliance with Title VII of the Civil Rights Act and is truly giving everyone an equal opportunity to succeed. Records also provide documentation to defend and even drive employment decisions. For example, they can help when defending against a lawsuit brought by an employee or employees under one of the employment laws. All the federal employment laws we will discuss today have record retention requirements, usually 1 to 3 years as a minimum. Good judgment and sound business practices may suggest that certain records should be retained longer. A general rule of thumb is to keep all employment records at least 3 years unless you are aware of a pending change or lawsuit, or if you believe one may be filed. In that case, Relevant records must be retained until the legal matter has been resolved. Records should be stored in a safe and secure place so that only authorized personnel have access to them. Since many employment records contain personal or confidential information about employees and the organization, they need to be discarded or disposed of properly and in full. Paper records should be shredded and computer files completely erased. As an employer, there are a few options for retaining your records. Things to consider when choosing a method for record retention include security level and accessibility. One of the most common systems is the use of a metal filing cabinet, usually kept on-site that is locked. A filing cabinet is probably the least secure place for legal documents, as your documents are only safe as the lock on the office door and the lock on the file cabinet itself. Also, your documents are susceptible to potential disasters like fires or floods. However, your documents are fairly accessible in an emergency, and anyone with a key to your office and the file cabinet can access them as long as they know where to find them. Of course, they can also be easily accessed by a thief who breaks into your office, so please be aware of that. Another method is online or cloud document storage, which has increasingly become a popular storage method. Online document storage allows you to store digital versions of your legal documents online. Be aware that simply scanning and uploading your files to a specific HR drive that isn't password protected is highly discouraged. Information should be password protected at all times so other employees don't have access to their coworkers' confidential information. Storing your documents online is very secure as long as it is password protected. Your legal documents can be accessed for the people who have the password and you have granted access to view the documents. Of course, make sure that you select a hard-to-guess password to protect your documents. Online storage is nice because files can be accessed anywhere at any time from a computer with web access capabilities. Are you using a lot of storage space to store records and information, or are they stored in your office basement? Off-site record storage will help you realize the cost savings associated with freeing up that expensive space, as well as enhancing productivity of the personnel who have to manage the information on-site. This is a great alternative to on-site storage. Off-site record storage and management can help you lower your operating costs, improve employee productivity, create more value from information assets, and protect your information from the risk of litigation, audit, and disaster. Record management and archiving offsite record storage programs have helped businesses and organizations save up to 50% by lowering costs associated with storage space, personnel, and records management. Safety and confidentiality of important records and files is often taken too lightly. Today, businesses can quickly become overwhelmed with attempts to comply with privacy standards, sensitive document handling, and even more protection from fraud and identity theft. Are the people authorized to view your records the only ones with access to them? Make sure that your files and records only end up in the hands of those authorized to view them. Some records become costly to store due to storage climate requirements. Find a facility that is climate controlled to ensure the longevity of the records in a variety of media formats. Natural disasters can destroy years of important and confidential information. Most off-site facilities are designed to safeguard your records from disaster. No more worrying about what will happen to your files in the event of a natural disaster like fire or a flood in your facility. There is no more need for information to be stored in your site, as offsite storage usually services are 24/7. That includes pickup, delivery, inventory, retrieval, data archiving, business continuity, and destruction of records and files 24/7. This is a critical part to making your information easy to access and easy to use. In most cases, businesses and organizations who store large amounts of files are doing so unnecessarily, and those who do not retain a large amount of files are discarding important information that should legally be retained. Creating a document life cycle and management record storage program will help determine which files to maintain, how long to do so, and how to legally dispose of them when the records are no longer needed. Depending on the legal authority and the type of record, statutory retention requirements can vary from 1 to 30 years after termination of employment. Keeping up with these individual requirements and establishing a workable tickler system to identify when and which records may be safely destroyed can be cumbersome even for small workplaces. Therefore, if the availability of secure file storage space is not an issue, adherence to the following general safe harbor retention periods may be preferable to researching applicable state or federal law and calculating the unique retention period required for each individual state, record type, and employee in question. Some suggested timelines include 7 years after termination of employment for personnel records, 6 years as long as no toxic exposure occurred for medical and benefit records. For employment verification such as I-9, 3 years after termination. Hiring and application records, 2 years after related personnel decisions. Any other miscellaneous documents and records related to a charge, complaint, enforcement action, or other compliance review should be held until the final disposition of the related action. For notices, posting notices as required by employment laws make employees aware of their rights under the law and sends a message that the organization takes the law and regulations seriously. Make sure that all required notices are posted, accurate or up to date, and post fresh copies of notices as needed. For instance, if notices are hard to read or are showing signs of wear, it may be time to replace them. To keep notices from getting frayed, defaced, or lost, it is a good idea to hang them in glass or clear plastic cases. Now let's look carefully at the requirements of major federal employment laws, starting with the Age Discrimination in Employment Act, or ADEA. The ADEA prohibits employment decision on the basis of age. This law protects workers age 40 and older. It requires employers to keep a number of important records. You must keep application records, including job applications, resumes, candidate test records, physical exam results, job ads, internal notices, and other forms of job inquiries. Keep records of personal activity such as promotions, demotions, transfers, training selection, layoffs, recalls, or terminations. Also keep payroll records that include each employee's name, address, date of birth, occupation, rate of pay, and weekly pay. You must retain records of job orders submitted to employment agencies. Also keep records concerning employee benefits plans, including the names of participants. All the records just mentioned must be retained for at least 1 year, except payroll records, which must be retained for 3 years. If a discrimination action under the ADEA is brought against an employer, all records regarding the employee or employees who filed the complaint or lawsuit should be retained until the final disposition of the action. It is a good idea to get signed waivers of ADA rights to sue for age discrimination from employees in the protected age group over 40 who leave your employment. An amendment to the ADEA, the Older Workers Benefit Protection Act, makes waivers legal as long as the employee understands what he or she is signing, is advised to consult with an attorney before signing, and signs voluntarily. Waivers should be retained for at least 1 year from the date employee terminates. The Americans with Disabilities Act, or ADA, prohibits employers from discriminating against individuals on the basis of disability. Employers must keep a number of key documents to satisfy the record-keeping requirements of this act. First, keep application records such as resumes, application forms, notes about reference checks, and medical records. Retain records of personnel activities such as promotions, demotions, training selection, apprenticeship programs, transfers, layoffs, or terminations. Also keep payroll records such as rates of pay or other compensation information. Retain applications for disability benefits or other medical records. And finally, keep requests for job accommodations and any written responses to those requests. All records associated with ADA compliance should be retained for at least 1 year from the time the record was made or the personnel action was taken. Keep in mind that information from medical exams is confidential and must be maintained separately from other records. Access to these medical records is limited to the employees, supervisors, and managers, safety personnel, workers' compensation insurers, and the employer's general insurance carrier. Once a discrimination legal action begins, the employer must retain all records regarding the employee until the final disposition of the action. The Civil Rights Act of 1964 was a landmark piece of legislation that helped to inspire laws such as the ADEA and the ADA. Title VII of the Civil Rights Act prohibits employment discrimination because of race, color, religion, sex, or national origin. The law requires employers to retain numerous records. Title VII requires employers with 15 or more employees to keep application records such as job resume, application form, and notes on reference checks. You also must keep records of personnel activity such as promotions, demotions, training and apprenticeship programs, transfers, layoffs, and terminations. Keep payroll records that show rate of pay or other compensation information. In addition, employers with 100 or more employees must keep Form EO-1 at each unit or company headquarters and file it annually with the Equal Employment Opportunity Commission. All records required by Title VII must be kept for at least 1 year. And when discrimination charges are filed under Title VII, employers must retain all records regarding the employee or employees until final disposition of the action. So let's stop for a moment and test your knowledge. So as we study the implications of the key federal acts, it's easy to get caught up in the kinds of records we need to keep and for how long, and to forget what the laws are all about. So as we go through this, note that one of the acts covers 2 of the answers. And here are the answers. The ADA covers disabled workers. The Civil Rights Act covers racial, religious, and national origin discriminations and women. And the ADEA covers workers over the age of 40. How did you do? Did you get all of them right? If not, we suggest going back and reviewing the areas that you were not so sure on. Now let's focus on the Consolidated Omnibus Budget Reconciliation Act, better known as COBRA. COBRA provides continuation of health insurance for employees and their families who lose their coverage because of termination, reduction of hours, divorce, or other life events. Record keeping is not required by COBRA. However, it is best practice to keep certain related documentation since proof of compliance with COBRA is required, and records are usually the best way to prove compliance. It is therefore recommended that plan administrators keep all group health plan records, such as lists of employees covered, lists of employees denied coverage, and a written description of any changes made to the plans. Keep records of all personnel activities, such as terminations, hour reductions, leaves of absence, and deaths of covered employees. Keep the names of employees eligible for Medicare, and keep records of employees' disability status. And that's not all. It is also recommended that you retain the names of retirees covered by a group health plan, records of premium payments, and completed forms that from employees electing COBRA coverage. That's quite a bit of paper for an act that requires no records. Each employee's record should be retained for as long as the employee or family member is covered by COBRA. It is also a good idea to keep records of notification to employees or other qualified beneficiaries of their rights under COBRA. This can be useful in cases in which people claim that they weren't informed of their rights. The Employee Polygraph Protection Act, or EPPA, bars lie detector tests to screen job applicants and limits the use of polygraph tests by employers for current employees. When polygraph tests are used to investigate a possible employee theft, for example, the law requires employees to keep certain records. These include a copy of the statement provided to the employee specifying the incident under investigation, the basis for testing, the loss suffered by the employer, and the nature of the employee's access to the relevant person or property. The notice given to the polygraph examiner identifying the person or persons to be examined, documents related to testing, such as questions asked, reports, or other documentation, and any other records given to the employer by the examiner. EPPA records must be stored in a safe place and kept confidential. Disclosure of test records is limited to the person examined, the employer, courts, and government agencies that are authorized by the court to see the information. Records should be retained for 3 years from the date of the test or from when the test was scheduled if it was not actually taken. The Employee Retirement Income Security Act, or ERISA, governs retirement and other employee benefits and requires employers to keep records relevant to these benefit plans. For example, employers must keep all records supporting the data in Summary Plan Descriptions, or SPDs. In addition, employers must retain annual reports for all benefit plans, including pension records and reports. Also, retain records needed to determine eligibility for benefits under ERISA. And finally, records should generally be retained for 6 years, although records needed to determine eligibility for benefits should be kept for as long as relevant. The Equal Pay Act requires equal pay for equal work regardless of an employee's sex. This federal law also requires employers to keep a number of key records. Employers must retain wage records, including payments, rates, and other descriptions or explanations of wage differentials for employees of opposite sex in the same job position. Relevant job evaluations and job descriptions. Also retain records of merit or seniority systems. And finally, retain records under the Equal Pay Act for at least 3 years. The Equal Pay Act is actually part of another act called the Fair Labor Standards Act, or FLSA. In addition to requiring equal pay regardless of sex, the FLSA has some other important provisions. It sets the minimum hourly wage, the minimum training wage, and overtime hours and rates. It also encompasses child labor laws, including minimum ages and the type of jobs and hours minors are allowed to work. This law requires employers to keep a variety of records. To begin with, employers must keep information about their employees, including their name, address, occupation, date of birth if under the age of 19, and gender. You also need to keep complete payroll records, documents concerning union agreements, and any written agreement concerning training. These need to be kept at least for the duration of the training period. You must also retain certificates of age for employees covered by child labor rules, at least under the minor employee terminates. All of these records must be retained for at least 3 years unless otherwise noted. In addition to the records we've just discussed, FLSA requires employers to keep several other important documents. Keep wage rates, tables, and wage records such as additions to and deductions from wages, Furthermore, as we have already mentioned, under the Equal Pay Act, records must be kept of wage differential payments to employees of the opposite sex in the same job. Also, keep records of job evaluations and descriptions, records of merit or seniority systems, and all of these records must be retained for at least 2 years. The Family and Medical Leave Act, or FMLA, allows eligible employees up to 12 weeks of unpaid leave in a 12-month period for qualifying medical and family reasons. It also allows eligible employees up to 26 weeks of unpaid leave in a 12-month period if the employee is the spouse, parent, child, or next of kin caring for a service member covered from an injury or illness suffered while on active duty in the armed forces. The FMLA has several record-keeping requirements. Employers must keep identification data for all employees, including name, address, occupation, and hours worked. It's also essential to retain detailed payroll records. Retain other necessary records, such as documents designating a leave as an FMLA leave, dates and hours of FMLA leave taken by employees, and documentation of any disputes over FMLA leave, including any written statements from the employer or employee. Keep copies of notices given to employees describing leave benefits and policies, and keep records of premium payments for employee benefits. FMLA records must be retained for at least 3 years and must be available for inspection by the Department of Labor upon request. Employee or family medical records must be kept separate and confidentially in compliance with the requirements of the Americans with Disabilities Act, which we've discussed earlier. The only exception to this confidentiality provision are the following. Supervisors and managers may be informed of necessary restrictions on work, and first aid providers and safety personnel may be informed on a need-to-know basis. Finally, government officials conducting an investigation under pertinent laws, such as the ADEA or FMLA, may be provided with relevant information. Records may be kept on the computer as long as they are available for transcription or copying. Employers are also required to post in a conspicuous place a notice explaining the FMLA requirements and providing information on filing procedures for violation complaints. Note that covered employers are required to post this notice regardless of whether they have eligible employees. Employers must include information about employee rights and obligations under FMLA in the employee handbook or collective bargaining agreements. If handbooks or other written materials do not exist, provide general written guidelines about employee rights and obligations under FMLA whenever an employee requests leave. The Immigration Reform and Control Act prohibits the hiring of illegal aliens. Under this act, all employees must certify that they are U.S. citizens or legal aliens and that they have legal permit to work in the United States. Employers must verify on the Immigration and Naturalization Services Employment Eligibility Verification Form, otherwise known as Form I-9, to identify an authority to work of all employees. Failure to comply can result in civil and, in some cases, criminal penalties. Keeping copies of supporting identification and work authorization documents in addition to the I-9 forms is recommended, although it is not required by law. Records should be retained for 3 years after hire or 1 year after termination, whichever date is later. The Occupational Safety and Health Act, or OSHA, requires employers to provide employees with a workplace free from recognized hazards. Employers with 10 or more employees are required to keep certain key records for occupational safety and health administration. All accidents resulting in death, days away from work, restricted work, transfer to another job, treatment beyond first aid, loss of consciousness, or diagnosis of a significant injury or illness by a physician must be recorded and updated on the OSHA Form 300, the log of work-related injuries and illnesses. OSHA Form 301 is an injury and illness incident report and must be completed for each entry in the Form 300 log. This report includes more detailed data about how the injury or illness occurred. OSHA Form 300A is an annual summary of which the total number of work-related injuries and illness for the year taken from the Form 300 log must be recorded. The OSHA Form 300 Injury and Illness Log, the Form 300A Annual Summary, and all Form 301 Incident Reports should be kept for a minimum of 5 years following the year to which they relate. Employers must also keep old OSHA Forms 200 and 101, which are replaced by Forms 300 and 301 in 2002, for 5 years following the year to which they relate. Records of any medical examination required by OSHA or by exposure to toxic or hazardous substances should be retained for 30 years after the employee terminates employment. OSHA has designated certain injury and illness records as privacy concern cases. Privacy concern cases involve injuries or illnesses to an intimate body part or the reproductive system, a sexual assault injury or illness, mental illness, HIV infection, hepatitis, tuberculosis, needle stick injuries, and cuts from objects contaminated with blood or other infectious material. Employers with a privacy case may not enter the employee's name on the logs, but rather should enter privacy concern case in place of the name. Then employers must keep separate confidential lists of case numbers and employee names so that the case may be identified and updated. Now let's turn our attention from record keeping to notices. Almost all federal and most state employment laws have some notice requirements. These notice requirements instruct employers to post notices in the workplace to advise employees of their rights under the particular law. The federal government has consolidated some of its posters to simplify posting requirements, which means that the same poster may be used to meet the requirements of several different laws in some cases. All posters are available from the U.S. Department of Labor. The laws all state that notices must be posted in conspicuous locations where employees are likely to see them, for example, on employee bulletin boards, at the employee entrances and exits or near time clocks, in the employee cafeteria, lunchroom or break room, and other such places. Posters must be maintained in good, legible condition, and as I've said in the past, a case is often used to protect them from getting damaged. Posters for many of these laws we've discussed are available in Spanish as well as English. And finally, penalties for violation of notice requirements may be quite high, so make sure you are always in compliance and display posters properly. On the other hand, may be helpful in defending against discrimination charges in some cases. A variety of posters should be on display in the workplace to meet the notice requirements of the federal employment laws we've discussed today. The Consolidated EEO poster satisfies the notice requirements of the Age Discrimination in Employment Act, the Americans with Disabilities Act, Title VII, and the Equal Pay Act. A poster titled Your Rights Under the Fair Labor Standards Act satisfies the notice requirements of the Fair Labor Standards Act, or FLSA. The Employee Polygraph Protection Act requires employers to display the Notice of Protection poster. The OSHA poster is titled Job Safety and Health Protection. The Federal Safety and Health Law also requires employers to post OSHA Form 300A, the annual summary of work-related injuries and illnesses from February 1st through April 30th each year. This form should be posted in a conspicuous place where you post other employee notices, for example, Job Safety and Health Protection poster. Finally, a notice outlining the provisions of the FMLA must be posted that explains FMLA provisions and procedures for filing complaints under the Act. Employers may obtain a poster from a local office of the Wage and Hour Division. So let's stop again and see how you have retained the material you've just heard. Here we see the names of 4 posters on the left and the acts they represent on the right. Let's see how well you can match the posters to the correct act. And here are the answers. Your rights under FLSA goes with the Fair Labor Standards Act. Consolidated EEO goes with the Age Discrimination and Employment Act, the Americans with Disabilities Act, Title VII of the Civil Rights Act, and the Equal Pay Act. Notice of Protection goes with the Employee Polygraph Protection Act. And finally, Job Safety and Health Protection goes with OSHA. How well did we do? The record-keeping requirements we've just discussed are minimums based on specific requirements set forth by federal laws. However, many employers may wish to keep records even longer, especially since the 2009 passage of the LILLY-LEDBETTER Fair Pay Act. Although the LEDBETTER Act does not contain specific record-keeping requirements, it has changed the landscape of employee record-keeping since its passage. The LEDBETTER Act provides when an employee is affected by a discriminatory pay decision or practice, then each paycheck that is issued based on the pay decision or practice constitutes an individual discriminatory act in itself. The practical effect of this law is that each time an employee is paid where the pay has been affected by unlawful discrimination, then the employee's time limit to file a claim for pay discrimination resets. The record-keeping issue arises if the original decision upon which the employee's pay was based occurred many years in the past. For example, in the case upon which the LILLY-LEDBETTER Act was based, this discriminatory pay decision had occurred more than 20 years in the past. However, LILLY-LEDBETTER argued, and the LILLY-LEDBETTER Act now holds that every subsequent paycheck she received was a new act of discrimination stemming from that decision made 20 years in the past. The Act creates a difficult record-keeping burden for employers, as an employer now in a position to defend against such a charge of discrimination would be required to prove that no discrimination occurred, a process that could require unearthing records related to payroll decisions made well outside federal and state statutory record retention requirements, as well as records related to similarly situated employees who may have long since left the company. As a result, employers concerned about defending charges of pay discrimination may opt to preserve personnel records, particularly those related to pay decisions such as promotions or evaluations, for a longer period than the statutory requirements. If you are concerned that your compensation plan may be discriminatory or that current pay decisions may retain ties to past discriminatory practices, consultation with legal counsel is recommended both to address and remedy the compensation plan and to establish pay practices for managing records related to compensation practices. So what are your next steps? We suggest reviewing your existing record retention policies and consider revising. Maintaining records indefinitely is a possibility, but not realistic for all. Most documents have no federal guidelines for retention. Don't want to maintain any records which are not required and which may be liability going forward. Look at industry requirements or prevailing industry standards. Using reasonable judgment may be judged by standard adopted by others in your industry. Many industries have provided guidance, such as the Association of Records Management and Administrators, American National Standards Institute, and the International Organization for Standardization. Other legal considerations, like the company's litigation history and anticipated litigation risks, review and update pay and performance management practices, policies, and records, train managers on new risks, conduct an assessment of compensation practices, and look at continued costs of risks of retaining records beyond what is required and useful, including storage, litigation, and search. Now let's look at litigation risk and retention guidelines. Do you have a document retention policy in place? The policy should establish procedures for employees to report to a responsible decision maker any information relating to potential litigation. The policy should require reporting to legal department or outsourced legal counsel, and the procedures should establish reasonableness and fair faith in meeting duty to preserve. Train employees on when to raise matters with legal department or legal counsel. Complaints and subpoenas should automatically go to legal departments or legal counsel, and legal departments can then investigate and evaluate necessity of a hold. A company must preserve all information that is reasonably believed relevant to anticipated litigation. This includes all documents or electronically stored information in the possession, custody, or control of the company. The company should suspend its customary deletion of data that is relevant, including backup tapes that may contain relevant information. A company is not required to preserve every document or email, but only those that the company determines may be relevant to pending or threatened litigation. Consider the following in determining the scope of information that should be preserved, such as the nature of the issue raised in the matter, experience in similar circumstances, and the amount of controversy. And what should you do when it comes to record retention? Here's a little to-do list. Examine current record retention guidelines against federal and state guidelines. Determine a consistent and reasonable retention period for all documents. Communicate across other locations, if applicable, to make sure all locations are on the same page when it comes to record retention. Keep documents centralized for record retention. Ensure supervisors are not keeping satellite files or desk files, but they should not be retaining anything else besides emergency contact information. Schedule specific timeframes for purging documents appropriately. Create a destruction log and destroy records by shredding to protect confidential information. And you may want to consider using an outside firm to do this for you. With that, that concludes the presentation on how long do I keep it. We welcome any and all questions you have regarding record retention. For questions or assistance with setting up a record retention schedule, please reach out to your dedicated consultant. We hope you enjoyed this presentation.